Hi guys, welcome to my channel, The Legal Affair with myself, Attorney Bay. As always, we talk all things law, and our conversation today is on contracts. We look specifically at contracts that relate to vehicle financing with banks. Please do, of course, remember to subscribe to our channel, The Legal Affair. You can also follow us on social media at The Legal Affair. You can also follow me on TikTok and Twitter at attorney_bay. That's at attorney_bay. So, of course, when it comes to vehicle financing and contract that relate to vehicle financing, if you do apply for vehicle financing and your vehicle financing is approved, the bank financing or granting you vehicle financing is likely to give you a contract. That contract, of course, will set out the terms and conditions that relate to the particular vehicle that the bank will purchase on your behalf. I do, of course, think like every other contract, it is important that you actually read the contract and you understand the terms and conditions of that particular contract, specifically because you are binding yourself to those terms and conditions. And should you not comply with those terms and conditions, you are likely to be in breach, and there will be consequences for you should you not comply with those particular terms and conditions. So really our conversation today is just understanding a few important clauses that relate to contracts when it comes to vehicle financing. Now, the first such a clause is a clause that relates to insurance. So if a bank is purchasing a vehicle on your behalf, ownership of that particular vehicle doesn't vest with you. Ownership vests with the bank, and usually the bank remains the owner of that particular vehicle up until the vehicle is paid in full, subject to terms and conditions, of course. So while the vehicle belongs to the bank, you'd find in many instances that the terms and conditions provide that as a consumer, you have an obligation to ensure that that vehicle is always insured, or you have insurance for that particular vehicle. So it's very important that when you actually purchase a vehicle, you understand what the terms and conditions of that particular agreement set out when it relates to insurance. Another important clause when it comes to terms and conditions for contracts for vehicle financing is the clause that relates to modification. Now, like I'd mentioned, in many instances, if a bank is purchasing a vehicle on your behalf, ownership of that particular vehicle vests with the bank. So should you want to make modifications, you as the consumer usually have an obligation to firstly notify the bank in writing that you would like to make the modifications, and secondly, and perhaps most importantly, is that the bank must consent in writing to you modifying the vehicle. So in other words, the bank must actually give you permission to modify the vehicle. And should you modify the vehicle without permission or consent from the bank, you would find that you might be in breach. In other words, you are non-compliant with the terms and conditions of your contract. So another important clause when it comes to contracts that relate to vehicle financing is a clause in relation to the Consumer Protection Act. Now, the Consumer Protection Act is probably the most important law we have in South Africa when it comes to the rights of consumers. It's quite extensive in trying to protect the rights of consumers and places various obligations on service providers. The application of the Consumer Protection Act differs, but there are instances where it is applicable. One such an instance is with a product that is directly marketed. So in other words, when a bank calls you, they contact you telephonically, "Hi, Ms. Mtshali, you qualify for vehicle financing for X amount. Would you like to finance a vehicle with us as a particular bank?" So if you receive marketing directly from a bank, either telephonically, via email, or via SMS, that is direct marketing. Now, when it comes to direct marketing, the Consumer Protection Act is applicable. There are, of course, various other instances that find or give application to the Consumer Protection Act, but I'm only using the direct marketing example. So with a product that is directly marketed, for instance, by a bank offering you credits for a vehicle financing or any other form of credits, you as a consumer have the right to a cooling off period. So what the cooling off period does, you have a limited number of days within which you can return a particular good. So if you purchase a vehicle on a Monday and Tuesday morning you wake up and you realize that actually I don't want this particular vehicle, you as a consumer I have a right to the cooling off period. Like I've mentioned, the cooling off period is a limited number of days, and it's important that that product must be a product that was directly marketed to you for the cooling off period to be applicable. Another such important clause, and I think perhaps the most important clause when it comes to vehicle financing, is a clause that relates to breach. So in very simple terms, breach means you are non-compliant with the terms and conditions of your particular contract and your contract relating to vehicle financing. So an example of breach, for instance, would be if the terms and conditions for the contract relating to your vehicle financing set out that you need to have insurance, and you find yourself not having insurance for your particular vehicle, that would mean that you are in breach of contract. Another example of breach, for instance, is if you modify a vehicle without the consent of the particular bank, and if the terms and conditions of your vehicle financing contract state that the bank must expressly in writing give you consent prior to you making modifications. Should you, of course, make those modifications without the consent of the bank, you find yourself in breach. So, like I said, breach means that you are non-compliant with the terms and conditions relating to a particular contract. Now, a very common form of breach also when it comes to vehicle financing is non-payment by consumers. So, in other words, you miss a payment or you skip a payment. Very common terms and conditions that we see is that when it comes to vehicle financing, consumers usually have an obligation to notify the bank that they are unable to pay the vehicle. So when it comes to breach, of course, you as a consumer have rights, and the bank also has rights. Now, a common right that you have as a consumer is the right to be notified by the bank. So you would find in an instance where you have skipped payment or you've skipped a number of payments, the bank will normally contact you telephonically, in some instances via email, and notify you that you are in breach. The bank also has an obligation to afford you the opportunity to fix or to remedy the breach in question. Now, when it comes to credit agreements and credit agreements, for instance, a vehicle financing agreement, there are various laws that are applicable. One such a law is the National Credit Act. Now, the application of the National Credit Act varies. There are credit agreements or vehicle financing agreement where the National Credit Act is applicable, and vehicle financing agreements where the National Credit Act is not applicable. So if you are in breach and the National Credit Act is applicable to your particular agreement or contract relating to vehicle financing, the bank usually has an obligation, according to the National Credit Act, to dispatch a letter of demand. So in other words, they must notify you. After notifying, usually telephonically, they must notify you in writing that you are in breach of your particular contract, you have skipped payment, you are in arrears, the amounts that which you are indebted towards the bank, and of course afford you the opportunity to remedy that particular issue or non-payment in relation to that your vehicle financing. So in many instances, you find consumers don't actually respond to the bank telephonically. They don't respond to the bank when they dispatch a letter of demand, and you put yourself in a very difficult position. Now, another important thing to bear in mind, from my experience having been on a panel for a particular bank, is that when the attorneys do a certain or achieve a certain milestone, they are paid by the bank. So, for instance, if the attorneys issue a letter of demand, they get payment from the bank. If the attorneys issue summons, they get paid from the bank. So, the attorneys have to move a matter. For instance, if you're defaulting on your vehicle agreement within certain time frames, so you get a letter of demand, you're given a 10-day period, and should you not comply with the 10-day period, it's likely that the bank will issue summons. So it is, of course, an incentive for the attorneys to try and move the matter quickly. And quickly, I use the word quickly very loosely because they have to move it within a certain time frame. So, like I said, if the letter of demand gives you 10 days, they can only issue summons after the 10-day period. So I think it's quite important, if you find yourself as a consumer in breach of your particular agreement, to notify the bank, usually because the terms and conditions of your particular vehicle financing contract set out that should you be unable to pay for your vehicle on a month-to-month basis because you've agreed to do so, you have an obligation to notify the bank. Now, another important and perhaps the last important term and condition in relation to vehicle financing is a voluntary surrender. So what a voluntary surrender does is that it enables a consumer to voluntarily surrender their vehicle to the bank. In other words, you take your car to the bank that granted you vehicle financing. The bank rather does an inspection on the vehicle. They sell the vehicle, and then you become liable for whatever costs are outstanding. Now, I think there are quite a number of terms and conditions that are important in relation to vehicle financing, but the voluntary surrender are probably the most important. And like every other contract, like I say, it is very important to read the terms and conditions of a contract. Once your vehicle financing application is approved, I think it's important to always keep a copy of the vehicle financing agreement that the bank rather grants you. But like always, go through your vehicle financing agreement, understand the terms and conditions, specifically because you are binding yourself to those particular terms and conditions.